Okay, welcome everybody to Lecture 10 of the Land Contracts block. Now, tonight's festivities, we're going to, got a few topics to look at tonight. And I know that you've done this before in regard to earlier subjects, but I just want to actually just go over this with you again so that it's a bit of a refresher. How Acts of Parliament are made and subordinate information. I also we'll have a quick reminder looking at legislation and so on Ostley. I'm not going to spend too much time on that because I'm fearful you might fall asleep on me. I'm pretty confident that most of you now have got your head around that. But I just want to just go over a couple of things with you. And then I want to look at a little bit on statutory interpretation, and I'll do a little exercise with you and explain something about that to you. And then what I want to do is have a look at contracts and just follow on from statutory interpretation. Instead of interpreting Acts of Parliament, then having a look at what the approach of the courts are to interpreting contracts terms. And what we'll also do is have a look at how the Australian consumer law can also affect in contract law terms in certain situations. And I'll go over a little bit of legislation with you. Now, I've done a little diagram which will probably help in that section, because whenever I've talked about sections 23 to section 27 in the past, I often see students' eyes glazing over. So I've done a little diagram, and I hope it'll make things a little bit easier. And then what I want to do is have a little talk to you about special conditions and drafting, and do a little exercise with you on that one. So the first thing which I want to have a look at tonight is just Acts of Parliament. Okay, we talked about different areas of law last time, and I'm just going to go read through this little thing I put on the tonight's festivities, and just go through it with you, and just and also you'll find a little diagram which I've taken. It's a nice little table which I've taken from a textbook, which has a nice little diagram on how different stages of bills. It's taken from Vickery Flood, and you'll see that in tonight's outline, the last but one page. So that's really very much what I just want to go through. The first thing to understand is the first question is to always ask, well, what new laws are needed? Okay. Now, why are new laws needed? Well, that could be a number of reasons, because society has changed and the current laws aren't meeting society's needs. On top of that, you may have lobby groups who are raising awareness to certain issues. You may even have the media, which may be running campaigns on problems which have developed. And so ultimately, what may happen is there may be a need for new laws in an area. You may also have what I call election promises. You know, when there's an election and certain parties will be saying to the electorate, if you vote for us, we will make these changes, which will ultimately mean that certain laws will be brought in.
They'll try.
Many examples, every election there'll be something, new laws which they're going to talk about bringing in as part of election promises. The most obvious, and going back a while now, was significant, like when the GST, remember there was an election 10 years or so, 12 years ago now, where the Conservatives, the Liberals I should say, went to the election. They said, if you vote for us, we'll be bringing in a GST. So that can be a key during election promises. Many examples, every election you'll see that. And so the key thing is, once there's been a decision that legislation is needed, a draft law or a bill is prepared ordinarily by Parliamentary Council, and that will normally be introduced by the party in power, who will usually have a majority of seats in the which House of Parliament?
Lower house.
The lower house, thank you. So usually it will be introduced into the lower house of Parliament, and it's read 3 times and discussed and voted on, and if it's passed in the lower house, it will usually then be sent to the upper house for the same process, and they'll debate and agree, and sometimes amendments will be agreed if it may pass one house but not the other. But ultimately, if the bill is approved by both houses with a majority approval, then the governor, if it's a state bill, or the Governor-General, if it's a federal bill, will give the royal assent, and it's approved and the bill becomes an act. It will then be published in the Government Gazette and usually proclaimed from that date onwards as law, or a specific date may be set or left to the government to decide where time is needed to implement the act. But this process doesn't happen overnight. It's a long process. It's being read in the House 3 times, so it takes a lot of time. Okay. Now, last week we talked about a different form of legislation. Remember, we looked on the board and we had legislation. We had something else which we called... I tested you last week and you didn't give me the answer. No. Legislation, we had Acts of Parliament, legislation, and then underneath that we had a different form of legislation which we called what?
You're talking about the regs.
Yes, what's the legal term for that? Subordinate or delegated legislation. Okay, and those being quite rightly the best examples of those are regulations. Now, and the subordinate or delegated legislation, regulations, best examples, we have bylaws by councils, ordinances, usually are made in territories, and they're normally prepared by government departments and authorities and local councils that are given delegated powers by the Parliament. The Act makes, as we talked about last time, the Acts of Parliament give laws in specific areas, but the regs are detailed practical rules that support the application of the Act. There's an old saying, the devil is in the detail, and quite often lawyers and so on will wait to see what the regulations actually say before they make any comment about the Act to see how the practicality of what's being suggested in the Act will be carried out. So, usually they're drafted by specialist public servants in the relevant areas who will usually be experts, and they'll be approved by the Governor or the Governor-General on the advice of the Executive Council, Cabinet or Government Ministers as part of that Cabinet process. Now, the time to actually do this is much, much quicker because it doesn't have to go through all these Houses of Parliament. Okay, for approval, it can be prepared much quicker and actually approved much quicker. And what will, on that basis, what does happen is they have what are called scrutiny committees, where usually a small committee will get together and will actually review regulations and subordinate legislation to make sure that they're satisfied with them. And one thing always is to make sure that the regs are prepared and they don't go beyond the power that's been given to them in the actual Act itself. I often think these scrutiny committees must be not the most thrilling job, but an important job. That makes sense. So essentially, that's an important distinction to compare the time it takes to actually do both of these. Now, when we looked at OSLI, okay, I just want to do a little bit of refresher with you guys, just to make sure you don't forget, because OSLI is really it's a fantastic thing. I don't want to turn into a nerd here, but OSLI is just so fantastic. It's so easy to use, and you can get so much information. I can't sing its praises enough, really, because once you start using it, you get your head around it. It actually becomes very simple. And so when we actually look at OSLI, when you go on to OSLI, straight away we can see all the different jurisdictions. And so, for example, if we click on South Australia, we've then got a choice: South Australian case law, South Australian legislation. Clicking on South Australian legislation, we can then go to South Australian current acts. And then we can actually have got the alphabet we can choose. And so if we I know that you absolutely love this act, the Land and Business Sale and Conveyancing Act. It's your favourite act. We can do an L and we can find the act straight away. And bingo, we're on to the act. Hopefully it will load in a moment. And always, take a few moments to look at the contents before you actually look at the act itself. And the table of provisions, which sets out each section. And one I particularly like is the scrolling down, the legislative history. If we want to see if there are any recent amendments, we can look at the legislative history and just follow it down to see when the last act was passed. And that tells us a little bit about it. And you can also see what sections of the act have been amended by different acts over the years. So that's great. Now, with the regulations under this act, as we've spoken about before, how it sets up a lot of the practicalities. And you guys, for example, have used various forms, haven't you? Which all come from these regs, and fees and so on are set in the regs. So that's really, really awesome, isn't it? A question we had earlier tonight, talking about jurisdiction. How did we find the Australian consumer law? And so if we go out of the South Australian database, and go to the Commonwealth, do the same thing, Commonwealth legislation, Commonwealth Consolidated Acts. We'll go into C for the competition, if I can find it, Competition and Consumer Act. Sometimes with Commonwealth Acts, sometimes they might have the word Australian put at the front, so that can sometimes throw us off. But Competition and Consumer Act, we can have a quick look at that. I know this is riveting stuff, but we'll get there shortly. And we've got all the contents. And the question was asked earlier this evening was, where's the Australian consumer law? Well, it's in this Act, but we have to go to the very end of it, to Schedule 2, and we've got the Australian consumer law. Now, a little trick, which I'm just going to show you. Well, no, it's worked now, it looks like. Australian consumer law, Schedule 2. And we've got all the sections. See how many sections of the Australian consumer law there are? So many. Okay. And sometimes when you click on that, you only get the first page or two. So sometimes you have to go out and click back in. But in any event, try and use Ostley and get used to using it, because it's very useful. Any questions on that before we move on to the next riveting subject?
Yes.
Yeah.
Just say you didn't know the consumer one was under Commonwealth. Can you do a search in the search bar?
I'm sure we can. Search. Let's go out. Let's go out of this completely. Okay. Let's see what happens. Search. Just let's see if we put Australian consumer law. It's actually very unusual to have that in such a large body of. There we go. So Australian consumer law, we put in the searches and it has come up. All right, Schedule 2. All right, it's just up here as a search.
Because not everyone will know how to find it.
No. And that's why it's a case of, encouraging you to use it and get used to it.
Yeah, navigate around it.
But particularly as many of you are millennials who have got great computer skills and know exactly what they're doing with all this technology. All right, so you've got no excuses. Okay, and also we also talked about previously the Code of Conduct, didn't we? You can do a Google search for the AIC Code of Conduct. I'm not going to bother doing that now, where you can find various rules under the Code of Conduct. Just to explain the whole idea behind codes of conduct. Okay, they're not laws as such. They're basically voluntary codes, for the most part, set up by industries for their members. And in some industries, which are not regulated very well at all, okay, the industries get together and quite often their attitude is, do we want these guys in Parliament passing laws for us and interfering in what we do. And what do you think their general answer is to that? No, we don't want members of Parliament sticking their nose in and telling us what to do. So how do we make it look good? And also, how do we try and show that we don't need regulation? Well, they may set up a voluntary code of conduct, which they get their members to agree to. And quite often it may work, because what then happens is the members comply with the rules of the voluntary code of conduct, and it's quite well self-regulated, and there may not be many consumer complaints from you and I, and so because there aren't many complaints, there aren't many problems, then Parliament says, well, we haven't got problems here, why bother interfering? That's not the case behind, in my view anyway, the Code of Conduct of Conveyancers, because we've already got regulations, quite significant regulations on what the professionalism of conveyancers. But the Code of Conduct in our industry is very much aimed at, increasing the skills and making sure we are ethical, all right, rather than trying to keep, the lawyers out, the law Parliament out.
If you breach the codes of conduct, if you breach it, there's still got to be someone can make a complaint to the Commissioner, can't they?
Well, they can still make under the Conveyancers Act. They can still make complaints about your conduct, whether provided it warrants a complaint. But we have to also understand that with the Code of Conduct, usually there'll be an internal mechanism. Usually, that the association will deal with the complaint first.
Law Society.
Yes, exactly the same principle. Yeah. But of course, remember that usually these are not mandatory codes. All right, the codes are only going to usually apply to the.
Some businesses also have codes of conduct and mission statements.
That's right, but usually they're voluntary.
Yes.
Okay, so you always have to look at what the code says usually at the beginning to say who it applies to, and usually they find they're voluntary codes. So for the members of the association.
So you're saying on Ostley they've got the code of conduct on?
No. I was just going to do
I've never seen it before. That's why
I was just going to do a Google search and get the Australian.
I've never thought it's got no business really on there.
No, it's not a law as such.
That's right.
Okay, all right.
The ASA code though basically just mirrors the requirements of the legislation anyway.
A lot of the sections do, don't they? When you had a look at it in that first assignment, you could see, particularly when you looked at conflicts of interest, you could see how exactly what you've just said.
Yes.
Okay, now something else I want to do with you guys. Now we've got a brief refresher on that, which I think you've had enough now of that, I think that's quite sufficient. So now I want to do a little exercise with you. Okay. Now, Bo, I'm going to pick on you.
Yep.
Bo is a member of Parliament, and his constituents. Any volunteers? Despina, Michael, on separate occasions, have both come to Bow as their Member of Parliament, and they've complained about sexual harassment carrying on, whether it be in the workplace, in a public street, etc., etc. And Bow has had this tearful complaint from Despina, and a tearful complaint from Michael, and a very angry complaint from Julie. And Bow has decided, well, this is clearly a matter of public concern, and he raises the issue with other cabinet members such as Jane, Wisdom, Prairie, Giddish, and they realise that yes, it's time that legislation in this area was enacted at the state level, and that the bill goes through Parliament as the Sexual Harassment Bill of 2019, and then ultimately it goes through the Houses of Parliament. And the Houses of Parliament in South Australia, guys, the lower house in South Australia is called what?
Legislative Assembly? No, lower house.
Lower house is called the what?
Yeah, that's right. The Legislative Assembly, isn't that right? Houses.
No, it's the Federal is the House of Representatives.
Federal is the House of Representatives. So 1,000 miles away, you've told me the name of the house, the lower house of Parliament. The upper house at the federal level is the what?
Senate.
Senate? Fantastic. In England, the lower house of Parliament is...
Lords. House of Lords. No.
The lower house of Parliament in England is what? Nobody? Good, I'm glad you didn't get that. The upper house at the federal level is the...
We're talking federal or state?
Well, I'm just testing you now. We're talking federal. You told me the lower house of Parliament at the federal level is what?
The House of Reps.
House of Representatives. And the upper house at the federal level is called?
Senate.
The Senate. Fantastic. You've told me the answer from the Parliament that's, 1,200 miles away? Now, the House of Parliament for South Australia, which is 500 yards away, up the road here, the lower house is called the what?
Isn't that the Legislative Assembly? No.
I didn't know yards.
What's the upper house of the South Australian Parliament called? Don't look at your notes, the answer's not there.
Could be the senator.
So what you guys are telling me is you can tell me the name of the House of Parliament 1,200 miles away, but you can't tell me the names of the Houses of Parliament 500 yards up the street here.
Isn't it just cabinet? No, that's a cabinet.
No?
Did I get it the reverse? That the upper house is the Legislative Assembly?
There's merit in your madness, I'll give you that. Okay, we've got South Australia, House of Assembly, and the Legislative Council.
Oh, it is
Anyway.
the council.
Legislative Council, the upper house. Well, that was very, very, what's the word?
Polly.
Encouraging. Okay, so here in South Australia, you put this bill through, and it's passed. And Bo, you're very happy that it's gone through.
Okay.
We can't have sexual harassment happening in our state. This is just a disgraceful thing. Okay. Now, the bill is actually prepared and it's passed. Now, I've just written a couple of excerpts on the board. And I'll just read through it for the sake of the distant students. It's a fictitious act, remember. Sexual Harassment Act 2019, Section 1, Interpretation. Sexual harassment or sexually harass means... Section 5, any man who sexually harasses a woman shall be guilty of an offence. Penalty $10,000. And quite right. Any problems any issues? Is that fine? No dramas?
Don't like that.
Don't like that? No?
Because females can harass
Yeah,
males.
well,
too.
Oh, thank you.
You're being gender specific.
We're being very gender specific in how it's written, isn't it?
Yes.
You're quite right.
Very Victorian.
Very Victorian. So, you're quite right. It's very gender specific. Any man who sexually harasses a woman. It's very specific, isn't it? as you said, it does. The way it's written, it doesn't cover if a woman harasses a man.
Yes.
It wouldn't cover
A man harasses a man?
if a man harasses a man,
Or
or if a
Woman harasses another woman.
or if a woman harasses another woman.
Yeah.
So we can see here there is a problem in the way this is written. Okay, and so the first rule of statutory interpretation is a rule called the literal rule. Okay, now the literal meaning, and this means that the ordinary words are used in the interpretation of a section of an act. Okay, now another rule that we have is one called. We've got another one which I've got for you called the golden rule or the absurd rule. Another rule we have is called the mischief rule, and the other side of the coin to that is the purpose rule. Now, if the court was to apply a literal interpretation on that section, okay, we would clearly have a problem. Okay? And what we need to understand is historically the attitudes of the courts were as follows. And I'll speak in the first person as if I'll elevate myself to judge status. Okay? Wouldn't that be nice? Okay? My job isn't to write acts of Parliament. My job is to interpret it. If Parliament takes 6 months or a year to actually get this act together and actually pass it, whose fault is it that they made a mistake? Yes, Parliament. They should have got it right in the first place, which means that I can only interpret what I see in front of me according to what they've decreed. So consequently, if you want to remedy this, then you need to amend the act. By applying a literal interpretation, then clearly this section would mean I'd only apply it to where a man harassed a woman. The problem with that, as you've all recognised, is that's pretty inefficient, isn't it? Okay, and I'll give you another example. And this one is a case where, in most jurisdictions where people do not have a will, okay, their property on their death will quite usually go to their closest living relative. Okay? And so it usually goes by their blood and it will go to their closest living relative. Now,
I thought it went to the...
in different jurisdictions. Okay, I'm not talking about a specific jurisdiction, I'm talking about a general jurisdictions. Okay? Generally across the board. Okay? Now, in a particular case, the statute in question said that without a will, that on the person's death, the person's property would go to their, quote, issue. Okay? Which would indicate by the word issue, which would most people would mean their children. Okay? Now, the son, there was one son in the family, and he, unfortunately, his mother died, and so consequently, under the statute, as the only living son, he was entitled to inherit the estate. Sounds fair? So far, it sounds fair, doesn't it? It does sound fair, doesn't it? No problem with that. No, there was no brother or sister. There was just one little problem. He had killed his mother. Okay? Now, the court looked at this and said, well, hold on. This is an absurdity. It would be absurd to allow him to benefit from her death in view of the fact that he was charged with, he committed the murder, basically. Okay? So, they looked at the literal rule and said, well, okay, that would appear to be that he would inherit, but applying the golden, or what I call it, the absurd rule, okay, it wasn't. They applied the rule, said it'd be absurd to enable him to inherit, and so they wouldn't allow it on that interpretation, using the golden rule. The problem is that these rules is not that clear when the judges are going to actually apply them. So the next rule we're going to look at is the one called... The mischief rule basically looks at... well, we'll come back to that in a moment. I'll explain what that rule is. But I'll give you another example. Okay? And this is actually another English example. They obviously had a number of problems in their parliamentary process. But what happened was, this is about 50 years ago now, members of the public, just like we just talked about, were getting very, very concerned, okay, about members of the public being solicited by prostitutes, okay, which was happening on the streets and so on. And there was a particular area, street in London, where this was very common. And so they passed what was called the Street Offences Act. Okay? And what the section basically said was that it was an offence to solicit another person for the purposes of prostitution on a street. Okay? On a street. Okay? Now, in this particular London street, the prostitutes on that street were, how shall I say it? I don't like to say they weren't ordinary prostitutes, because that's just getting off. It's not a comedic manner. But they were charged with breaching this section. And he went to court, and one of the prostitutes was on the witness box, and the prostitute essentially said, "Do you plead guilty?" "Not guilty." And he goes to the witness stand and the matters, and she says, the prostitute essentially said this: "Your Honour, I was not on a street. Your Honour, I was on a balcony. I'd moved to the balcony, which was above the street." And so what these persons were doing was that they'd moved from the street, got onto a balcony, and then they were beckoning people who were walking by.
Oh, smart.
I thought it was smart, actually. I thought it was a smart argument, yes. And that's what I was trying to say. They weren't ordinary, the fact that they were smart in this argument. But the court basically said, well, Now, if we look at the mischief rule, and I apply the purpose rule also, they're kind of two sides of the same coin. The mischief rule basically enables, okay, the court to look at what the defect in the law was before the Act of Parliament was passed, to see what it was aimed at remedying, if you like. The purpose rule, which is the other side of the coin, basically enables the court's judges to actually look at what was the purpose of the Act of Parliament, or the purpose of the section. Okay? And the purpose of this Act of Parliament essentially was to
stop people getting harassed.
To stop people getting harassed, solicited by prostitution for the purposes of prostitution. So the court said, despite your argument, the fact that the purpose of the Act was to stop people being solicited, so consequently the prostitute was still in breach of the section. Does that kind of make sense? Mm-hmm. Okay. Now, so the purpose rule is what is quite often used. What you often find is the literal approach is quite often, more often than not, applied, particularly in the lower courts. But on appeal, you'll often find the judges, if there is an issue, may actually interpret one of the other rules to overrule a magistrate on appeal. Okay.
So that one could have also been the mischief law, even though he used the
That's right. You could, in this one, you could apply the mischief or purpose rule and say, well, what was the purpose of this fictitious act? To stop people being sexually harassed. And so the judges in this situation applying that rule would say, well, okay, clearly they've made a mistake here, but the purpose is to stop sexual harassment in all its forms, and so they would interpret it so that if Larry brought a complaint that Lionel was sexually harassing him, or Debbie complained that Deirdre was sexually harassing her, that they would still fall within the section. Does this kind of make sense?
Oh, no, I meant the dead man. That could have been either as well. Not the dead man, the dead mother.
Yes, the dead mother.
Yeah. That could have been either, yeah. I'm
not sure on that one, because they specifically applied the absurd rule. But But then, really, the maxim that no man or woman should benefit from their own malfeasance is probably another equitable principle which would come in anyway.
That still applies.
Okay, so the absurd rule
Yeah.
is the same thing as the common rule.
Yeah.
You know.
Oh, see, that must have been a really long time ago, that case study, wasn't it?
The dead one? Oh, many years ago, yeah.
And this one too, they're probably 100 years ago or something.
No, I think the street offences was about the 1960s, 70s, I think. Yeah. Okay, so...
Going from Curry Street, that could go over to Kimberley Road.
Yeah, off the street and onto the road. That's what I thought, they just went down the road. What's going on here?
well,
It's in the street. So
So they're on the same level.
well, this is it, and just on that thing, yeah. Anyway, I'll leave that one with you. Okay, I'm not going to get into trouble on this area, but the key thing to understand is that those are the approaches which the judges will normally have a look at, and we also have. So the mischief purpose rule, we also have an Acts Interpretation Act, where most jurisdictions have them, which will detail which will provide certain definitions. Okay, if something isn't an act, you can quite often go to the Acts Interpretation Act and see if a definition for that word or whatever the case may be is in there.
Same as on the Form 1. You go and you look at what the definition of the word.
Well, I'm not on a particular form yet, but in the Acts Interpretation Act, it will usually apply to all acts of Parliament to see if it hasn't been defined, you may be able to find a definition in there. And I think in your second assignment, you need to have a look at that act to see particularly on the contents page, to see if there's any information that can help you in one of the questions. So now we've just talked about statutory interpretation. Okay, that's where judges will actually interpret acts of Parliament. So those rules apply to acts of Parliament interpretation. We also need to have a brief look at contractual terms and interpretation. So what's the judge's approach when they look at contracts? Okay, so the first thing which I've written down here for you is judges would generally look at the plain and ordinary meaning of the words used. Okay, but they'll usually ask ourselves the question, what does the contract state? What was intended by the words used and the legal effect of those contractual terms? Judges will look at the contract as a whole. So they'll look at the contract as a whole. If the words are unambiguous, judges will give effect to that meaning. To determine the meaning of the contract terms, judges will normally try to determine what the parties' objective mutual intention was and not their actual intention. Okay? So what would a reasonable person believe, looking at the negotiations and so on, their objective intention was? What a reasonable person would have thought was intended by the term if that person was in the situation of the parties, what the parties objectively sought to achieve as opposed to the outcomes that an individual hoped for. So I may have hoped for many things, but that may not necessarily mean what the objective interpretation of the contract is. What does this mean? It's, the High Court has recently interpreted the construction of a term on the basis that the parties were to be understood as having intended to produce a result consistent with the commercial object of the agreement. What's he talking about? What does this mean? Okay. Well, the best way I can actually explain this to you is just get you to have a look at the case that I found for you on the back page. ECOS against GD nominees. Okay, just have a read of that short case note. Okay, which ironically you can find on Osley. Okay. Have a short read of this. It's quite an interesting, unusual little case, but quite interesting. Last page. That's it. ECOS Property Holdings against GD nominees. Distant students, please have a read of that case note as well. Okay, so this is quite an interesting little case, isn't it, really, when we look at it? It says in the second paragraph, the agreement was a standard form printed farm lease to which they made amendments. Due to a planning restriction affecting subdivision, the owner of the land, the subject of the lease, could not sell it to the lessee, i.e. the tenant. Clause 13 provided a clause in it, and then it went on to say, so that basically the parties acknowledged it was the intention of the lessor to sell and the lessee, that's the tenant, to purchase the land and improvements hereby leased for the consideration of $70,000. And as a result thereof, the parties have agreed to enter into this lease for a term of 99 years. So because they can't sell the fee simple, or whatever the subdivision is here, they're going to have a 99-year lease, in respect of which the total rental thereof is the sum of $70,000, which sum is hereby acknowledged to have been paid in full. So they're going to get $70,000 for the 99-year lease. And then the clause 4 basically then imposes the obligation, and also will pay all rates and taxes, assessment and outgoings whatsoever, which during the said term shall be payable by the tenant in respect of the said premises. So basically saying all the rates, taxes and so on are going to be paid by the tenant. So it looks like what the purpose behind that is so that it's going to be as close as possible to a sale. So really what the landlord or the lessor is really stepping back. They've had the money and you get on with your lease, and really you're doing whatever. You carry on paying the fees and it's all up to you. And, of course, in 2013, the lessor or landlord commenced proceedings in the Supreme Court of Victoria seeking a declaration that the lease requires the lessee to pay all rates, taxes, assessment and outgoings in respect of the land. The judge agreed and made the declarations, but then the tenant appealed, and the Court of Appeal by majority allowed an appeal by the lessee and set aside the orders of the primary judge. So the tenant suddenly thinks, well, hold on a minute. I don't want to pay this money. And the landlord should be paying this because we've got a landlord-tenant situation. This is going to save me quite a bit of money each year. One thing about contract law, guys, it's so predictable. It's usually always about money. Okay? And so it goes to the High Court, and the majority of the High Court held that the lessor's construction of Clause 4 was to be preferred. The Court approached the question of the proper construction of Clause 4 on the basis that the parties were to be understood as having intended to produce a result consistent with the commercial object of the agreement. The majority said that the parties intended to create as far as possible in a lease the conditions which would have existed following a sale. The majority held that it made no commercial sense, having regard to that objective, for the lessor to remain liable for the payment of rates, taxes and other outgoings over the terms of the lease. Okay, so that's quite a nice example of looking at how the objective approach was applied.